3 words. Are you armed? And in the 2 seconds it takes you to decide how to answer, 2 things are already happening simultaneously. The officer is watching your hands, your eyes, your body language, and your hesitation, all of it going into a mental report that will inform every decision he makes for the rest of that encounter. And you are about to say something that, depending on what it is, will either protect you or expose you to a legal sequence most drivers never see coming until they are already inside it. Yes produces an immediate escalation. No produces a statement that, if it turns out to be wrong, becomes a lie on a law enforcement record. And the response most drivers instinctively reach for, the honest, transparent, cooperative answer, is the one that consistently produces the worst outcomes. Because this question is not a safety conversation, it is an investigative tool, and the law gives you a complete, constitutional, on-camera answer to it that most drivers have never heard. Subscribe to this channel right now, because the video after this one covers what happens the moment that question leads to a pat-down or a vehicle search, and those are 2 entirely different legal events with 2 entirely different sets of words that every driver carrying a firearm, legally or otherwise, needs to know before they ever need them. Before the words, you need to understand what the question "Are you armed?" actually is, because the way it sounds at a traffic stop and the legal function it serves are 2 entirely different things, and the gap between them is where most drivers make the mistake that costs them. The question sounds like a safety inquiry. It sounds like an officer who wants to know what he is dealing with so that everybody goes home safely. And officer safety is real. It is a legitimate concern that courts have repeatedly recognized, and that responsible drivers should take seriously. But the question "Are you armed?" is simultaneously an investigative question, one designed to elicit a verbal statement that will go into a report, that can be used to justify a search, that can form the basis of a weapons charge if the answer is inconsistent with what is subsequently found, and that creates a record of your acknowledgement of a firearm's presence before any independent evidence of that presence existed. When you answer yes, you have provided the officer with a verbal confirmation of a weapon's presence in the encounter. That confirmation justifies an immediate pat-down, justifies asking where the weapon is, justifies a heightened posture for the remainder of the stop, and in jurisdictions with specific disclosure laws, can become the basis of a charge if the disclosure is deemed deficient. When you answer no and a firearm is subsequently discovered, in a legal search, in an inventory, in a consent search you should not have agreed to, your no becomes a false statement to law enforcement, a fact pattern that prosecutors use to argue consciousness of guilt, and that can produce independent criminal exposure beyond whatever the underlying stop involved. The question is not casual. It is not a conversation opener. It is an evidence collection moment, and the answer you give, in either direction, is the evidence. Here is the legal landscape that makes this question more complicated than any other at a traffic stop, and it is the one piece of information that is most jurisdiction-specific, most variable, and most critical to understand before you ever find yourself answering it. Some states have mandatory disclosure laws. These statutes require a driver who is carrying a concealed firearm pursuant to a valid concealed carry permit to proactively disclose that fact to a law enforcement officer upon official contact, meaning you are legally required to tell the officer you are armed before he asks, typically when you first hand over your documents. Virginia, Michigan, Ohio, and several other states have versions of this requirement. Failure to disclose in a mandatory disclosure state is a criminal offense, and it is an offense that compounds everything else about the stop. Other states have duty to inform laws that are triggered only if the officer asks. In these jurisdictions, you are not required to volunteer the information, but once the officer asks directly, you are legally required to answer truthfully. Still, other states have no disclosure requirement at all. A driver with a valid concealed carry permit is under no legal obligation to inform an officer of the firearm's presence unless directly asked, and in some of those states, even a direct question does not create a legal obligation to answer. The variation across these 3 categories is enormous. The stakes of getting it wrong, answering in a way that violates your state's specific disclosure law, or answering in a way that creates criminal exposure in the other direction, are significant. This is the single topic in the entire series where knowing your specific state's law before you are in the encounter is not optional. It is essential. And it is exactly why the exact words you are about to learn are built to protect you across all three categories while you figure out which one you are in. Here is the constitutional foundation that every driver who legally carries a firearm needs to understand before they are ever asked that question at a window, because the Second Amendment and the Fourth Amendment operate simultaneously in a traffic stop firearm encounter. And understanding both is what allows you to navigate the moment without exposing yourself on either side. The Second Amendment protects the right to keep and bear arms. In District of Columbia versus Heller, the Supreme Court held that the Second Amendment protects an individual right to possess firearms independent of service in a militia, and that this right extends to self-defense in the home. In McDonald v. City of Chicago, the court incorporated that protection against the states, meaning state and local governments cannot eliminate the right. The right to carry outside the home has been addressed in New York State Rifle and Pistol Association versus Bruin, where the court held that the constitutional right to bear arms extends to public carry and that regulations on public carry must be consistent with the nation's historical tradition of firearm regulation. These decisions matter at a traffic stop because they establish that the lawful possession of a firearm, particularly by a driver with a valid concealed carry permit, is constitutionally protected conduct, not inherently suspicious conduct. The mere presence of a legally possessed firearm does not provide probable cause for a search. It does not transform a routine traffic stop into a Terry stop justifying a pat-down. It does not, standing alone, constitute the reasonable articulable suspicion of criminal activity that is required to extend a detention. A legally armed driver is exercising a constitutional right. That fact is relevant to how law enforcement is permitted to respond to the disclosure. Here is where the question becomes layered in a way that most legal commentary on traffic stops never fully addresses. The intersection of the Second Amendment right to bear arms and the Fifth Amendment right against self-incrimination. When a driver who is not in a mandatory disclosure state answers the question, "Are you armed?" they are providing a verbal statement about a fact that could incriminate them. If they are legally armed, the statement may trigger a search, a seizure of the weapon, and scrutiny of the permit that could surface issues. If they are illegally armed, an expired permit, a prohibited person status, a jurisdiction where carry is not permitted, the truthful answer is a direct self-incrimination. The Fifth Amendment protects against compelled self-incrimination. An officer asking a question at a traffic stop is not, by itself, compulsion in the constitutional sense. You are not under arrest, you are not in formal custody in the Berkmere v. McCarty framework. But the Fifth Amendment's protection against providing incriminating statements extends beyond formal custodial settings. And a driver who believes an honest answer to "Are you armed?" will expose them to criminal liability has a Fifth Amendment basis for declining to answer. The complexity here is real. In a mandatory disclosure state, the disclosure requirement has been structured specifically to override the Fifth Amendment concern. Courts have generally held that the state's interest in officer safety through mandatory disclosure is constitutionally balanced by the limited use immunity that some of these statutes provide. In a non-disclosure state, the Fifth Amendment argument is cleaner. In every state, knowing which framework applies before the encounter is what separates a driver who handles the moment correctly from a driver who guesses wrong under pressure and creates criminal exposure that did not exist before the stop began. Here is what most drivers do when they hear "Are you armed?" and every version of the instinctive answer creates a problem. The first driver who is legally carrying answers yes immediately, then volunteers the location of the weapon. "It is in my holster. It is in the glove box. It is under the seat." They think full transparency with a legal firearm is the safest approach. What they have done is provide the officer with a confirmed weapon location, justified an immediate pat-down, and potential weapon seizure for the duration of the stop, created a record of admission that will appear in the report regardless of how the stop ends, and in some jurisdictions, potentially triggered a review of their permit status that surfaces an issue they were not aware of. Transparency with a legal firearm is not always the wrong approach, but volunteering the location before understanding what the officer intends to do with that information is always premature. The second driver who is legally carrying answers no because they want the stop to end quickly and they think the weapon will not be discovered in a routine traffic stop. This is the most dangerous response available. If anything subsequently produces a search, a smell claim, a plain view observation, a consent they should not have given, an inventory following an impound. The no becomes a false statement on a law enforcement record. False statements to law enforcement officers are criminal offenses in most jurisdictions regardless of the underlying subject matter. A driver with a clean legal carry permit who said no and had the weapon found during a subsequent search has now created a weapons disclosure violation, a false statement charge, and handed the prosecutor a consciousness of guilt narrative, all because they gave the wrong one-word answer under pressure at a window. The third driver who is not carrying at all answers no honestly, but has still provided an on-camera statement that can be used in any way the investigation requires. No is not a neutral answer even when it is true. It is a statement that goes in the record. Here is the legal architecture that governs this moment, and it contains more protection than most drivers carrying a firearm have ever been told they have. In Terry v. Ohio, the Supreme Court established that a pat-down for weapons requires reasonable, articulable suspicion that a person is armed and dangerous, not simply armed. The dangerous element matters. A driver who discloses a legally carried firearm, presents a valid permit, and exhibits no threatening behavior has not provided the officer with reasonable, articulable suspicion that they are dangerous. The firearm is legal. The permit is valid. The conduct is protected. The legal disclosure of a lawfully carried firearm, without more, does not automatically satisfy the Terry standard for a pat-down. Courts have addressed this distinction in multiple jurisdictions. In United States v. Robinson, the Eighth Circuit addressed whether the presence of a legally possessed firearm, disclosed during a traffic stop, automatically justified a pat-down, and the analysis turned on the totality of circumstances rather than the mere presence of the weapon. In State v. Timberlake and related decisions, courts have examined the degree to which a disclosed concealed carry permit changes the Terry calculus, with results that vary by jurisdiction but consistently require something beyond mere possession to justify treating a licensed carrier as dangerous. The Bruin decision's articulation that lawful carry is constitutionally protected conduct has significant implications for how lower courts must assess the dangerousness prong of Terry in encounters with permit holders. A legal firearm, legally disclosed by a calm and cooperative driver, in a jurisdiction that recognizes the carry right, should not automatically trigger a Terry pat-down. Whether it does in practice is a different question, and the answer to that question is made on your body cam recording, by your conduct, and by what you said. So here are the exact words. And because the firearm question has multiple legal pathways depending on your state's disclosure law, there are two versions, and knowing which one applies to you requires knowing your jurisdiction's specific requirement. If you are in a state with a mandatory disclosure requirement, meaning you are legally obligated to inform the officer upon contact, the correct approach is to disclose proactively, before he asks, clearly and calmly. Officer, I want to inform you that I am a licensed concealed carry permit holder and I have a firearm in the vehicle. My permit is in my wallet with my license. How would you like me to proceed? You have satisfied the legal disclosure requirement. You have identified yourself as a permit holder, signaling lawful possession. You have offered your permit simultaneously with the disclosure, which documents that the possession is licensed. And you have asked for direction rather than acting unilaterally, which keeps your hands where the officer can see them and removes the ambiguity about movement that creates dangerous misunderstandings. If you are in a state without a mandatory disclosure requirement, or if you are uncertain which category applies and want to protect yourself while you assess, your response to "Are you armed?" is, Officer, on the advice of counsel, I respectfully decline to answer questions that may tend to incriminate me. I am invoking my Fifth Amendment right to remain silent on that subject. Am I free to go, or am I being detained? Say it calmly. Say it clearly. Say it without any physical movement that could be misinterpreted. Every word is doing legal work. On the advice of counsel, I respectfully decline to answer questions that may tend to incriminate me. You are framing the refusal as legally informed rather than evasive. You are invoking the specific constitutional protection that covers the question. You are not confirming or denying the presence of a firearm. Nothing about a weapon enters the record from your mouth. I am invoking my Fifth Amendment right to remain silent on that subject. Named. Specific. On camera. Knowing and voluntary. The same language that protects you across every other investigative question applies here with equal force. Am I free to go, or am I being detained? the legal hinge, forces the declaration, moves the burden. Here is the layer of this topic that no discussion of the legal words can omit. Because the "are you armed" question at a traffic stop is the encounter where the stakes of getting the physical conduct wrong are the highest of any moment in this series, and the words only protect you if the physical conduct does not undermine them. Keep your hands visible at all times from the moment the officer approaches. If you know you are carrying, put both hands on the steering wheel before he reaches the window and keep them there. Do not reach for anything, your wallet, your registration, your glove box, your phone, without first telling the officer what you are about to do and waiting for his acknowledgement. "Officer, my registration is in the glove box. May I reach for it?" This is not weakness. This is the conduct that keeps an encounter involving a firearm from becoming a tragedy. Never reach toward a weapon under any circumstances during a traffic stop. Never attempt to unholster, reposition, or secure a weapon during a stop. If you are asked to exit the vehicle and you are carrying, say so before you move. "Officer, I want to inform you that I am carrying. How would you like me to exit safely?" Give the officer the information he needs to manage the physical safety of the encounter before movement creates a dangerous ambiguity. The constitutional rights in this video protect your legal interests. Your physical conduct in this encounter protects your life. Both matter. Neither is optional. The officer will push back, and at a firearm question stop, the pushback will often be framed as a safety issue. An officer who says he just needs to know for everyone's protection. Know every variation before you hear it. If the officer says, "I need to know if there are any weapons in the vehicle for officer safety." Officer safety is a legitimate concern, but it does not override your Fifth Amendment right to remain silent. In a non-disclosure jurisdiction, the safety concern does not create a legal obligation to answer. Your response does not change. If the officer says, "If you are legally carrying, you have nothing to worry about, just tell me." This is the same compliance trap used at every stage of every stop in this series. A legally carried firearm disclosed at a window does not stay a simple disclosure. It becomes a pat-down, a weapon seizure for the duration of the stop, a permit verification, and a record. Your response does not change. "Officer, I once again invoke my Fifth Amendment right to remain silent on this subject, and I will not answer further questions without my attorney present." If the officer says, "Your refusal to answer tells me you might be armed," the inference an officer draws from a Fifth Amendment invocation cannot be used as the reasonable articulable suspicion required for a Terry pat-down in most jurisdictions. Silence is not a weapon. Your response does not change. If the officer says, "Step out of the vehicle," comply with the exit. Keep your hands visible. Move slowly and clearly. As you exit, "Officer, I am complying. I do not consent to any searches or pat-downs. Am I being detained, or am I free to go?" If a pat-down is attempted, "Officer, I do not consent to any pat-down or search of my person. Do you have reasonable articulable suspicion that I am armed and dangerous?" State it. Do not physically resist. Get it on the record. If handcuffs come out, "I want an attorney." For words, everything stops. Here is something that most concealed carry permit education programs do not cover, and it is the exposure that legally armed drivers create for themselves most often without realizing it. A concealed carry permit is a license issued under state law with specific conditions. Those conditions vary by state, but commonly include restrictions on where the firearm may be carried, requirements about how it must be stored in a vehicle, prohibitions on carrying in certain locations, and in some jurisdictions, requirements about the manner of carry. When a driver discloses a firearm at a traffic stop, they are not just disclosing a weapon. They are opening the door to a scrutiny of whether every condition of their permit is currently being met. Is the firearm stored in compliance with the permit's vehicle storage requirement? Is the location of the stop a permitted carry zone? Is the driver's permit current and valid in the jurisdiction where the stop is occurring? Reciprocity laws govern whether a permit issued in one state is recognized in another, and reciprocity agreements vary enormously. A permit that is valid in 38 states may not be valid in the state where the stop is occurring. A driver who discloses a firearm and whose out-of-state permit is not recognized by the stop jurisdiction has just provided the officer with the information needed to charge them with unlicensed carry. None of that exposure existed before the driver answered the question. All of it was created by the answer. Understanding your permit's specific conditions and the reciprocity status of your permit in states where you drive is the preparation that makes the encounter manageable. The words in this video are what protect you in the moment. The preparation is what makes the words work. The body cam captures the firearm question exchange in full, and it is one of the most consequential segments of footage in any case involving a weapon at a traffic stop, because every decision about the pat-down, the weapon seizure, the extended detention, and the charges that follow rides directly on what happened in the seconds after the officer asked those 3 words. Judges at suppression hearings watch the footage to assess whether the Terry standard was met before the pat-down began, whether the driver's conduct provided independent justification for the escalation, and whether the officer articulated sufficient basis for continuing the detention. Juries watch it to form their impression of whether the driver seemed dangerous, evasive, or simply calm and constitutionally informed. A driver who kept their hands visible, moved deliberately, spoke clearly, invoked their rights precisely, and gave the officer nothing aggressive to work with. That driver, on that footage, looks like someone who understood the law and used it. That is not the footage of a threat. That is the footage of a citizen who knew their rights. The roadside and the courtroom are connected by that recording. The firearm question is the moment that recording becomes most consequential. Make sure what it captures is a driver who was composed, precise, and protected, because they knew what to say before they ever needed to say it. Memorize these before you close this video. In a mandatory disclosure state, before he asks, as you hand over documents, "Officer, I want to inform you that I am a licensed concealed carry permit holder and I have a firearm in the vehicle. My permit is with my license. How would you like me to proceed?" In a non-disclosure state or when you are uncertain, when asked, "Are you armed?" "Officer, on the advice of counsel, I respectfully decline to answer questions that may tend to incriminate me. I am invoking my Fifth Amendment right to remain silent on that subject. Am I free to go or am I being detained?" If he pushes, "Officer, I once again invoke my Fifth Amendment right to remain silent, and I will not answer further questions without my attorney present." If a pat-down is attempted, "Officer, I do not consent to any pat-down or search of my person. Do you have reasonable articulable suspicion that I am armed and dangerous?" If the vehicle exit is ordered, comply slowly, hands visible, and continue invoking non-consent. If handcuffs come out, "I want an attorney." Know your state's disclosure law before you need it. Keep your hands visible throughout. Never reach toward a weapon. These are not just legal positions. At a firearm stop, they are the complete framework for going home safely and legally protected. This is educational content only and does not constitute legal advice. Always consult a licensed attorney in your jurisdiction for guidance specific to your circumstances. If this video reached you before an officer ever asked you those 3 words, it did exactly what it was built to do. Subscribe to this channel right now, because the firearm question is one of the most legally complex moments in a traffic stop, and it sits inside an encounter that has a dozen other moments, each with its own framework and its own words, that this channel covers one by one. Every video here is one scenario, one constitutional foundation, one set of exact words, built so that when the moment arrives, you are not guessing, you are not exposing yourself in either direction, and you are not turning a legal firearm into a criminal charge because you answered the wrong way under pressure. Subscribe. Share this with every driver you know who carries. Someone watching this tonight has a concealed carry permit, does not know their state's disclosure law, and is going to be asked that question on a dark road before they ever had the chance to prepare. Make sure they know what to say. Make sure they know how to say it. Make sure they go home protected. Stay calm. Stay protected. Stay free.